Welcome to the Law on Succession. The discussion contained in this series will be lifted from the book on succession by Paris. Let's dive straight into it. What is succession? In its general sense, it is defined as the transmission of rights and properties from one person to another. It may be inter vivos, during the lifetime of the giver, or mortis causa, after his death. In its technical sense, however, it is restricted to succession mortis causa. This means that succession will only be effective after the death of the giver. In the Philippines, we refer to this giver as the decedent, and transfer of title to property will only take place upon his death. There are several kinds of succession. We have already mentioned some of them, but let's look at the ways they are classified. As to effectivity, there are two kinds. Succession inter vivos, or ordinary donation, and succession mortis causa. This is the kind of succession meant in this subject. Succession can also be testamentary, when there is a will. It is intestate or legal succession when there is no will. It can also be mixed succession where part of the property is disposed of in a will, while the other part is not. Succession can also be compulsory succession, as when it refers to the legitime, or voluntary succession, as when it refers to free disposal. As to the extent of rights and obligations involved, succession can be universal, meaning it covers all juridical relations involving the deceased. It can also be particular, as when it covers only certain items or properties. There is also a special kind of succession called the contractual succession. This is a kind where a future husband and a future wife give to each other future property, effective mortis causa, by means of a marriage settlement. Chapter 1, General Provisions. Article 774. Succession is a mode of acquisition by virtue of which the property, rights, and obligations to the extent of the value of the inheritance of a person are transmitted through his death to another or others either by his will or by operation of law. Some important elements to consider in this definition are: first, mode of acquisition or ownership. Second, transfer of property, rights, and obligations to the extent of the value of the inheritance of a person. Third, transmission through death. Not during the lifetime of the person. Fourth, transmission to another. And fifth, by will or by operation of law. This is either through testamentary or legal succession. Article 775. In this title, decedent is the general term applied to the person whose property is transmitted through succession, whether or not he left a will. If he left a will, he is also called the testator. Important definitions to remember are: when the decedent left a will, he is also called the testator. On the other hand, if he did not leave a will, the decedent is also called an intestate. Article 776. The inheritance includes all the property, rights, and obligations of a person which are not extinguished by his death. We have to distinguish inheritance from succession. Inheritance is the property or right acquired, while succession is the manner by which the property or right is acquired. From these definitions, we can readily see that inheritance is the property itself, while succession is the process by which such property is transferred. We also distinguish succession from administration. Administration means dealing with the deceased person's property. Succession refers to the act of transferring the same. What does inheritance include? It includes property, rights not extinguished by death, and obligations not extinguished by death. We must take note, however, that the last item refers only to the extent of the value of the inheritance. What does the term property include? It includes real as well as personal properties. This accrues from the moment of death. We must remember, though, that the human corpse is not a property and is therefore not part of the estate. There is an exception here, where RA 1056 allows under certain conditions the granting to certain entities of a person's organs after death. Properties not belonging to the estate must be excluded because they are not part of the inheritance. As such, it is vital that ownership of the properties be determined before they are disposed of. When it comes to rights, it shall be noted that some rights are extinguished by death, and some are not. Examples of rights extinguished by death are the right to claim acknowledgement or recognition as a natural child and the right to hold public or private office or job. These rights have no inheritability. Meanwhile, rights not extinguished by death can be in the right to bring or continue an action for forcible entry or unlawful detainer. Some examples also include the right to compel the execution of a document necessary for convenience and the right to continue a lease contract either as lessor or lessee. As for obligations, the general rule is that all obligations are transmissible unless they are purely personal or non-transferable by law or contract. The important thing to remember here is that an heir will be liable to pay for the debts of his deceased parent, but only if the same can be covered by the inheritance. Judicial administration is not essential when the deceased left no pending obligations. Article 777. The rights to the succession are transmitted from the moment of the death of the decedent. There are conditions for the transmission of successional rights. They are: Number 1, death, whether actual or presumed. Number 2, that the rights or properties are indeed transmissible or descendable. Number 3, that the transferee is still alive, willing, and is capacitated to inherit. Since succession only takes place after the death of the decedent, it is important to talk about presumptive death. There are two kinds. Ordinary presumption because of ordinary absence. The period is 10 years, except for when the person disappeared after the age of 75. Here, the death is presumed to have occurred at the end of the 10-year or 5-year period as the case may be. Then there is the extraordinary presumption because of extraordinary or qualified absence. This topic is discussed in detail in the subject persons and family relations, so you can just revisit Article 391 of the Civil Code. What happens now if the absentee appears or even without appearing, his existence is proven? He shall be able to recover his property in the condition in which it may be found. The price of any property that may have been alienated or the property acquired therewith shall also be returned to him. However, he cannot claim either fruits or rent. Now we explain the effects of transmission of rights from death. It must be remembered that prior to a person's death, his heirs merely have an inchoate right to his property. That is, during his lifetime, the heirs have no right of disposition or alienation over said properties. However, after his death, the heirs are free to dispose of the same, subject to the decedent's liabilities. It is also noteworthy that while future inheritance cannot be sold, after the testator's death, the heir can sell his share in the estate even pending liquidation. This is because upon the death of the testator, the property ceases to be future property. It is already considered present inheritance, which may therefore be disposed of. There is no necessity for a prior declaration of heirship if there are no pending settlement proceedings for the distribution of an estate. Hence, the heirs are already allowed to begin an action arising from any right of the deceased, such as the right to bring an action to annul a deed of sale or to bring about a partition. As to administration, when the heirs are all of legal age, and there are no debts to be settled, there is generally no necessity to appoint an administrator. The heirs themselves may enter upon the administration of the property. In a case decided by the Supreme Court, It was ruled that the executor or administrator of the estate shall have the right to take possession of the properties of the deceased so long as it is necessary for the payment of the debt and expenses of administration. Where there are no debts to be paid, the estate should pass to the heirs. What is the effect of fraudulent intestate proceedings? If the heirs conceal the existence of other heirs and as a result of such concealment, the intestate proceedings should award them with property. The prejudiced heirs can still file an action to recover their shares, notwithstanding the termination of the settlement proceedings. This is because ownership of their shares accrues to them automatically upon the decedent's death. Meanwhile, if the heir instituted is incapacitated, repudiates the inheritance, or predeceases the testator, said heir inherits nothing. Estate tax must be computed as of the time of the decedent's death. The tax should be measured by the value of the estate as it stood at the time of the decedent's death, regardless of any subsequent contingency affecting its value. Article 778. Succession may be 1. Testamentary, 2. Legal or intestate, or 3. Mixed. Aside from the 3 kinds of succession enumerated in the law, there are 2 more. The first one is compulsory succession, also referred to as necessary or forced succession. It is named as such because it is compulsory for the testator to give his compulsory heirs their legitimes. This is not to say, though, that the heirs are compelled to receive or accept said legitimes. The second one is contractual succession. Here, it must be noted that this does not need the formalities of a will. A marriage settlement is sufficient. Article 779. Testamentary succession is that which results from the designation of an heir, made in a will executed in the form prescribed by law. Testamentary succession may be done through a will or through a codicil. A codicil, according to the American Heritage Dictionary of the English Language, is a writing by way of supplement to a will, and intended to be considered as a part of it, containing anything which the testator wishes to add, or a revocation or explanation of something contained in the will. The will or codicil may be notarial or holographic. In case of doubt, testamentary succession is preferred to legal or intestate succession. Article 780. Mixed succession is that effected partly by will and partly by operation of law. This article is pretty self-explanatory. Article 781. The inheritance of a person includes not only the property and the transmissible rights and obligations existing at the time of his death, but also those which have accrued thereto since the opening of the succession. Inheritance includes the property, transmissible rights, and obligations. For obligations, it only applies to the extent of the value of the inheritance. Inheritance also includes as well as those which have accrued thereto since the opening of the succession. It must also be noted that property acquired by the testator between the time the will is made and the time he dies is not given to the designated heir unless the contrary has been expressly provided. Article 782. An heir is a person called to the succession either by the provision of a will or by operation of law. Devisees and legatees are persons to whom gifts of real and personal property are respectively given by virtue of a will. They are called heirs if they succeed by universal title, that is, to all or a fraction or aliquot part of the properties, rights, and obligations. Meanwhile, they are called legatees and devisees if they succeed by particular title to cash or to a particular or specified item or thing in the inheritance. To distinguish, legatees succeed to particular personal properties while devisees succeed to particular real properties. Why is it important to know the difference between heirs and devisees or legatees? This comes into play in prioration. There will be a discussion on this topic in Article 854. This is the end of Chapter 1. See you all on the next episode, where we discuss succession further. Please like, comment, and subscribe for more.